Good afternoon, everyone, and congratulations on making it to the last session of the afternoon. Very good. First of all, can I apologize that it is me who's moderating this panel? I don't know if you know, but Jane unfortunately has COVID, so she won't be joining us. But I'm very lucky because I genuinely consider this to be the most interesting panel of the day. That's not trying to be rude to the other people, but I really think it is. As we have learned today, litigation funding is now a central feature of modern dispute resolutions. But as with any sophisticated financial world, everything doesn't always go according to plan. When cases don't perform as expected, when damages are lower, cases go on longer, when there are competing stakeholder priorities, or when budgets overrun, we start to see how resilient our structures and relationships really are. Over the next 50 minutes, we will look at what happens when things do go wrong, how courts approach fairness and distribution, how funders manage risk and relationships, and what practical steps can help preserve value in difficult situations. Now, we're very lucky, as you can see, to have a very experienced panel, despite the fact that Ayse, on the end there, is wearing a very dodgy T-shirt. I would like to, okay, thank you. I would like to welcome them all, and perhaps we can start with Zach, and maybe you can just give a brief introduction to yourself.
Sure. Hi, everyone. Thanks for sticking with us today. My name is Zachary. I'm the Managing Director of Legal Assets at Northwall Capital, which is a London-based private credit fund. I've been in litigation finance for almost a decade now. Prior to that, I was a litigator in the US at Quinn Emanuel and Sherman & Sterling before that.
Nick Bacon, KC, Head of Chambers at 4 New Square. Very nice to be here as always, and look forward to speaking to you all.
Christiane, Deniger, I'm a director and senior member of the arbitration team at Burford. I've been doing this for about 10 years. Prior to that, I was a litigator at 2 New York firms based in London and Paris.
Ayse Yazır, I'm the Managing Director of Benchmark Advisors. Prior to that, I worked at Burford. I'm also a chartered insurer. I work for a broker and worked as an underwriter, now funder.
Thank you. Look, it's very unusual that you speak to great crowds such as yourselves, and we're all on the same side. We love this industry. I certainly love it, and I think we're all on the same side. We try and do it the best we can. Over the last 15 years or so, some of us have made mistakes. Some of us have made more mistakes than others. I know I have. But I think the purpose of this afternoon is really to talk about some of the mistakes and see what has gone wrong and how we can make our industry, which really is incredible, I think, even better than it is today. So I've got loads of questions, and we can do that. But what I'd really like to do, if we can get some audience interaction, it would be great. You are here, you've got your own experiences, your own questions. Please use this panel if you can. I've got, as I say, some questions which I will prime them with, but if you can, please ask them, and we will try and learn something from this if we possibly can. So, I will kick off, and the first topic I'd like to cover is the rather intricate relationship between the law firms and funders, and how that should be managed and maintained right from the start of the case through the life cycle. Who would like to start with that?
I'm happy to start with that.
Okay, perfect. Thanks, Christine.
Whenever I start talking to a new lawyer that I haven't worked with before, I like to remind them that our relationship is a marriage and not a fling. We're going to be in here for several years, and we're not always going to be happy with each other, which is not always the best way to start a conversation, but it's true. Because at some point, someone is going to do something that the other side doesn't like, whether that is overspend, we might have a disagreement on strategy, or the client might just be annoying. So we need to figure out how to work together and get along. And it's not always easy, and there are people who, myself included, can be more difficult to work with. And it's finding a way to push through that and come up to a common goal. Because at the end of the day, the lawyers, the client, and us, we just want to make money and win.
I will follow the marriage conversation. I think like every marriage or relationship, communication is key. So it is so important to have a direct communication line, like Christiane mentioned as well, have a really good relationship with your lawyers and your clients. What we have seen in recent cases, like one of the biggest, I think, loss and the biggest fight that's happening is around Merrick's case. When you think about what's happening in Merrick's case, I think the main reason behind why the parties, like Christiane also mentioned, were fighting for a common goal, ended up in a huge court fight. Of course, what's happening at the end is now the parties are instructing lawyers are earning more and more money because they didn't have a clear communication line. They should be, when you are working in a team, you have to discuss everything. And when people ask me the question about what do you think about that case, I say to them that seems like a really bad divorce.
Mm-hmm. I agree, it's legitimate expectations. And looking back at Merrick's, everyone should have thought, well, will we be okay if the amount is X? I don't know if they had that conversation. Maybe they did, maybe they didn't. But at least from an outsider's perspective, it appears that nobody communicated with each other.
I think, just to sort of dovetailing on that, I mean, I think there's two aspects. Obviously, it is a relationship, and it's an ongoing relationship. And I'm originally from California. I don't want to sound sort of too woo-woo about it, but like you do have to develop trust, and you need to sort of develop enough of a reservoir of goodwill and trust amongst the parties that you can overcome some of those hurdles along the way. But then, of course, it's also about the structural arrangement, and it's about thinking about sort of stress testing the structure that you have in place and making sure that you have the alignment that's there that allows low-value settlements to make sense, that doesn't force the claimant to push ahead because you're going to take all of the money, and at the same time allow situations where they're going to trust you and their lawyers to push ahead. So I think you sort of have to think about it in two ways in terms of the sort of trust, but also the sort of structural arrangement that you have in place, and really testing that in different scenarios, including and it's the basic stuff that we do as underwriting, which is what happens when the damages are 20% of trial damages, because that's where cases settle most of the time. What happens when they say it's going to be a 3 or 4 year duration, but actually it takes 6 because that's what cases are taking these days. And what happens obviously when the budget goes over budget by 20, 30, 40%. And so stressing these, and what does that mean? It means that maybe less cases should be funded and get funded, and that just might be a reality of where we need to go.
Good. And are there any contractual tools that you can put into the contract beforehand to give you additional ways of bringing cases back on track?
So, I'll speak for a moment on that. I mean, I think obviously the waterfall and the alignment is probably the most critical piece. We're a credit fund, so we look at these things a little bit differently, and we don't have the sort of typical LFA that sort of a traditional funder uses. And I know there was a credit panel earlier which sort of gave that perspective. And I will say, there are lots of things in our funding agreements that maybe should give you comfort in terms of EODs and enforceability. But the reality is you shouldn't delude yourself, particularly if you're a credit fund, that these assets in the end are not something that you can really enforce on or really have sort of the kind of security that you would think of from a credit perspective. And so I really think in the end it comes down to sort of alignment and budgeting, really.
I mean, it's a very good point, Bobby, that you have raised. Are there going to be some contractual terms? Of course, we sign an LFA with the lawyers and the client when we are funding a case, but it is incredibly difficult to cover every single scenario on a piece of paper. If you try to do that, then you are going to end up with 60-page litigation funding agreement that client wouldn't understand anything. And also when we sign the case, there will be probably some parts that will not be covered. Like, again, I'm going to bring back to what I said before. When we are funding a case, we really, really interview and talk to lawyers. Because what we have is based on trust relationship with financial supporter to a person who has legal knowledge and the client. And unfortunately, maybe, of course, we all have some clauses saying if there is dispute, we are going to take you here. You know, settlement will be discussed with, if there is a reasonable settlement, they are going to discuss it with us. Or there might be some material adverse facts, but you can't cover everything in a contract.
And I think alongside that, one of the more important things of keeping things on track is active case management. You know, it's knowing what's happening in quite good detail across the cases and being sure that you're kept informed of any, not just material changes, but things that could impact the case. We're very lucky at Burford and a lot of the other funders, we have a lot of data that we can rely on for how past cases have gone. And by using that data, we can often foresee or hopefully predict how things will move under certain arbitrators and judges. And it's so important to keep active communication open.
Do you think maybe the funders are to blame sometimes? That, you know, certain funders are very happy to write the check on day one and then stand back and wait for it to come back in. Others are a lot more proactive. And I think if you actually look at a case, you know, lawyers are normal commercial lawyers. They're very smart. They are in the big London firms. They're working on one or two major cases at any one time. But I think sometimes they forget that funders are looking at 50 cases or 60 cases at any one time. So they have I would argue that they have a lot more experience, and sometimes the law firms should listen to the funders. Obviously, the funders can't direct the claim, but they've got a lot of experience that if you've got a good relationship, can be shared and can be positive for the case, I would say.
Yeah.
Great. Arbitration clauses, is that something that helps?
We wouldn't like to be in that situation. Of course, sometimes we always say if there's any dispute, we are going to use these courts. We have never been in that situation because of, I think, the way we work. We have very good relationship with the clients and lawyers. But if worst comes to worst, you will end there, but we never been in that situation. Touch wood.
It's not been my experience either, fortunately, but you know, we've seen some earlier this year that some of our other funders in the market had arbitrations with their former clients, and it's not a great place to be, but I believe they were successful in fighting it off.
Yeah, you know, I've sort of been of two minds on this. Obviously, there's sort of, you know, the traditional advantages of arbitration in terms of, you know, confidentiality, maybe speed, sort of some informality, and I think, you know, most funders as a sort of received wisdom would be, you know, you don't want these disputes in the press and in the public, but I do, you know, whenever we're looking at an opportunity, you know, we do think hard about who the counterparty is, what kind of a dispute might arise, whether it's more likely to be us in dispute, you know, us bringing a dispute or receiving a dispute. And I do, you know, we do certainly think hard about this and do put, you know, non-arbitration dispute provisions, you know, typically in, say, you know, New York courts or Delaware courts or where have you, where we think there might be some advantages in actually being able to litigate in a court system.
But it's not a great look, is it, when you're...
No, it's not.
No.
But it can have some advantages.
But for the, you know, for a defendant who's coming up towards trial and then spots the fact there's a massive arbitration between the funder and the solicitors on the other side, it's not a great look. These clauses are, you know, they're there, but query whether they're of any real use, utility.
Good. Well, look, obviously, most cases progress very smoothly, obviously, but in this industry at the moment, there's a lot of pressure, I think, on funders, and you may get a situation where funders have to excuse themselves or step down. How how do we cope with that, and are there sort of ways that we can facilitate that and sort of help the claimants and the case keep on track?
I think it depends on the context of why the funder is stepping away from the claim. If the funder finds out information about something potentially difficult that the claimant's done that would materially affect its case, there's no helping the claimant there. They've done something that could completely invalidate their case. If, however, it's a case where a funder is no longer able to fund because they don't have access to capital, then we often see other funders stepping into their shoes. And, you know, if it's a good case, someone will fund it.
I mean, it's a very difficult one. Stepping back means you are losing quite substantial amount of money that you have put in a case. That's why we try to push the case as much as we can when it comes to, you know, when it comes to either it can be arbitration case or it can be a competition case. If we are not successful, we try to appeal it and try to find a way to make it work rather than thinking about pulling out, because pulling out is a really big loss for a litigation funder.
I suppose one thing, just 2 points actually, just to mention, just back to the arbitration provision for a second. You know, one thing that I have seen be effective in some cases in heading off disputes is actually a mediation provision, or some kind of a provision that, you know, allows a third party, you know, a casee, to come in and just, you know, give a view. And sometimes that can be enough to, like, you know, bring the parties to a certain view to say, okay, well, actually this damages make sense, or, you know, this strategy makes sense. You know, just to mention that as something. And then in terms of the, you know, the question about sort of subsequent funding, I mean, I suppose, you know, this is not something that I would want as a funder, but certainly if I was a claimant, I would be, and I was looking for funding, I would certainly be thinking about the types of provisions that are in the funding agreement at the get-go in terms of the prior funder's return, and allowing something in there that allows a new funder to come in. You know, there's always going to be some kind of a negotiation, but if you can have some of that done ahead of time that says, you know, if the funder is terminating funding, maybe not for cause, but because they don't have sufficient capital or they don't no longer want to do the case, but the merits are still strong, then, you know, their entitlement is reduced, but it's still there in some respects, that they get their money back and a, you know, reasonable rate of return or what have you, rather than, you know, in some funding agreements, it may be the funder's position that despite terminating the funding, you know, it's still entitled to its, you know, 2 or 3x return, which can make it very hard to get subsequent funding.
And just one more point. It is a live example. What we had is we had a case that we suddenly realized that there were some issues with the case. The client has been involved, maybe some unacceptable behavior. And what we had there was when we were talking about, when we were talking to lawyers said, oh, this is a material adverse change, so I think you should stop funding. And we said, no, guys, we are not going to stop funding as yet, because, okay, great, you got 5 million in your pocket and you don't want to go to court or arbitration tribunal to fight on this case. But we were discussing with lawyers how can we pass through that. And what I see is, of course, it will change from lawyer to lawyer. In some cases, it is more common. Lawyers say, this is a material adverse change, okay, goodbye, let's stop funding. Rather than as a funder, I am actually putting 5 to 10 million on this case, and how am I going to save it back again?
Good point. Okay, that's the end of the questions I have for the relationship between the law firms and the funders. Does anyone in the audience have any additional questions on this part? Rob.
Yeah, I mean, it's a really good question, and you're right, that is a problem. But I've been in a case where there has been a fallout, and there's an agreement reached that there's an obligation at least to listen to the funder, who will instruct their own legal team. And that person, the individual who would be providing that, would be somebody that both sides are happy with. And so there's an obligation to listen, but not necessarily to adopt. I think that's okay. But you're right, you can't have a world where the funder says you must now do X, Y, Z, and you get into all sorts of trouble. You can in Australia, we're talking about, but here certainly, in Australia it's completely different. I mean, I'm doing a case out there actually, and it's the complete opposite. I think it might scale back, but in Australia, you can, the senior judiciary has no problem with the funders having direct control over the claim, including offers to settle and.
I've had direct control with the defendant.
Yeah.
So indirectly, it's quite unbelievable.
Yeah. So it's very different. I can't ever see that happening where we are in this jurisdiction. I think the common law is so embedded into our regime that governments and senior judiciary, I just don't think they like the idea that a claimant is sort of giving up the decision making to somebody who's got a financial return in the case. I'm afraid. I think that's where we're. But I mean, that is a solution. You get an agreement, an arrangement where you're obliged to listen. I mean, that's pretty fair.
Can I be cheeky and just take one other comment?
Yeah.
Am I the only person who knows in one of the CAP's recent judgments that they referred to the Australian system as evidence of a system where funding could be cheaper, but neglected to point out that the funders were the ones who were actually running the case.
Yeah.
And obviously, if you're running the case, you can control some of the risks that otherwise you can't.
Yeah.
Quite personally, I would not like to run any case. If I am going to be the person who will be running the case, bring the new cases, take the financial risk, I would rather take the gun and shoot myself. There's a reason. I think everyone has their own place. Litigation funders provide financing, and we are funding 350 cases at the moment, and we are only 12 people. I don't have no time to sit there and tell lawyers what they should do and they shouldn't do, because that's their job, quite frankly. And my job is, I'm a litigation funder, I give you the financing, please run the case. Of course, you need to let me every month what's happening with the case and we can discuss it. But if you are not competent enough to run your own cases, then I don't fund your cases.
I mean, I don't disagree with you, Ayse. We like to have a strategic discussion with the lawyers. Of course, they know very well they don't have to take our advice or views, but we like to just make sure that they're aware of what our views are. And there are some lawyers in some jurisdictions who do not take kindly to that. And there's some lawyers like here or Paris who are very happy to have full and frank strategy discussions. So it just depends on who you're dealing with.
Also, I think I'm not sure that the fundamental problem is control so much as in a lot of the cases that have gone wrong, either publicly or so privately. It's less about control. It's really duration in the end on many of these matters. The cases have just gone on for too long, and the budgets are overblown, or damages are lower. But that being said, while I agree that I think it's unlikely that in the UK and certainly in the US that you'll see substantial changes on the limitations on traditional litigation funders being able to sort of control their direct litigation. I do think you're going to see, and you are starting to see, new forms of capital entering into the market, and you're going to be in a situation where, there may be closer ties between the capital providers and the law firms. And so, whether that's through ABS structures, private equity firms that are doing roll-ups or what have you, the MSOs that your colleagues in the US have been talking about, I think those structures will, inevitably bring, greater level of control and direction by the lender or capital provider.
But I think that's one of the big issues. I mean, I have to say, I agree that is what is. So I mean, there's a very good example of that going on publicly at the moment, and I worry about that. I think there's, putting capital into a law firm is fine, but for those that are doing it, I do think the bottom line will be the judiciary would look at that very carefully. There needs to be a very clear dividing line between the decision making in the case within the firm and the funding of the firm.
We do a lot
Very
of law
important.
firm funding, and
Yeah.
we take a very careful
I
line
know you
there
do.
because we have to.
I know that, but there are the way that the market is going, at least arguably, potentially, the borders and the lines that you might draw are not as clear.
Great. So you had a question.
I think they answered it already. It's
Really?
about
That's good.
funding the law firm, and also about assignment, which is also another model of buying the claim completely. How does it change in that type of situations?
Yeah. Well, in the UK, we don't
No, you
We don't like that.
assignment.
In Spain, you're probably fine, but
Yeah.
it's not something that's permissible here. For a funder to sort of take an assignment of the claim in return for, 25% of the upside, it's not going to happen.
But it is interesting because, while we sort of all acknowledge, both the reality but also the sort of policy goal of, maintaining the lawyers, sort of independent counsel and maintaining the claimant's position in terms of, deciding settlement and strategy in conjunction with their lawyers. I mean, I do think you hit on something earlier, which is that, the funders often, because of the scope of the types of cases that they see, can be in a position to actually, be, perhaps in a better position to, to maybe not decide, but certainly in a better position to advise whether, the strategy makes sense or whether, it makes good economic sense to continue to fight or to settle this case. Whereas, the lawyers, even if they're hugely, hugely experienced lawyers, the number of cases that they've really tried, are still, maybe in the dozens and the many dozens. But as a funder, you do have a sort of wider scope on which to base some of those decisions and advice.
But that's achievable, like the gentleman was saying, that's achievable if you appoint somebody and you have an obligation to listen.
Mm-hmm.
All I'm saying is if you go a bit too far and demand what you want, then you're in a world of problems.
Okay, great. Thank you. That's very interesting. I'm going to ask one last time. Does anyone have any experiences, first-hand experiences of where funders step aside that they'd like to share? No. Okay.
That's great.
Perfect. So all is perfect. So we'll move on to my favourite topic, I think, the cat. And it's obviously they are looking at how they handle distribution, and they're looking how they can be fair and proportional. As a funder, I think it's slightly strange that you may get a situation where the CAT may just rip up a litigation funding agreement that has been agreed between the two parties, but I'm obviously slightly biased. And can we ask Nick to give your sort of view on the CAT?
The cat, yeah. So this is, I think at the moment, the climate and where we're at with the cat and funders is pretty critical, and there's lots going on at the moment which will affect the direction of travel. I'm pretty convinced of that. And one of the big issues is this distribution problem or issue, as it's been perceived, that we're now getting the sort of end of the beginnings of the end of a long tail on big cases that are coming to fruition in terms of settlement or resolution. They're turning out not to be as successful as they were predicted to be. The consequence is there's not enough money to go around, and you have this inevitable issue at the end of the case about how the damages are to be distributed to enable all of the stakeholders, including, of course, the class, to receive what is fair, just and appropriate for them to receive. And you have, on the one hand, the commercial litigation funders who've naturally secured funding from investors on the premise that this is my agreement, and if we win, this is what I get. Written in stone, here's a contract, it's all there. And then on the other side of the coin, you have the class and the class representative who said, well, I didn't actually agree anything, I left it to the tribunal to decide what to do. And this is now obviously coming to a head. And the the travel on this, I mean, obviously, we'll see how the cases and the judges deal with it, but speaking entirely for myself, the judges are going to want to find a way that keeps all of the stakeholders in a fair and just outcome. So by definition, they are, I think, you do end up logically in a world where, if you take it to its extreme, the argument, in a world where the funding agreement is probably not worth the paper it's written on, if that is the logical outcome. I think it possibly is. Taking it to its extreme. But I'm not sure that was, I'm not sure that this should come as a surprise to anybody, because settlement and distribution is a matter for the tribunal ultimately. And so as I see these funding agreements, I think there's, in the future we've got to look at a different way of funding these cases. That's my own view. The big topic on that. But the funding agreements really set the parameters, I think, of what the parties have agreed, but they don't actually bind the judge in the final analysis to what they've agreed. And it's an unsatisfactory position for funders, and it's unsatisfactory for the solicitors, and it's unsatisfactory for the class, because there's a lack of certainty. It's not ideal, and it needs looking at. Because you need certain, my own view is, right at the beginning, somebody needs to say, on the premise that we get this, or this is how I see the case in terms of funding, remuneration, lawyers' remuneration, so what the budget should look like and what the class would be left with. Some sort of grown-up discussion right at the beginning about what the likely scenarios are, and to plug in early on what those. Well, they don't do that. That's the problem. Is it doesn't happen. I agree with you. It should. It doesn't happen though. It's all left to the end. Now I can see why at the time that all seemed very sensible, but in the light of experience, I wonder whether it is really sensible, because it leads to such uncertainty, and then funders obviously say, well, I'm not funding a case that my contract's not worth anything, and I'm not funding a case if it means I'm not going to get paid what I've told my investors we're going to get paid. And then the client class rep says, I'm not going to take a case if I'm not going to get damages for the class, and it's all very uncertain. Certainty, to my mind, is like a key missing ingredient at the moment at the outset. Somehow we need to get to a point where there is greater certainty.
I mean, I agree with you entirely. Everyone in the market always says how risky and scary treaty arbitration is, which is what I like to do. But I think the CAT claims are way trickier. You don't have a tribunal ripping up sunk costs when they're calculating damages. That would just never happen if they're real. Whereas here, you have no idea what it's actually going to cost. And normally it's 20 or 30 million pounds. And there are very few cases that are generating the types of returns that will satisfy everyone. Keep me with my treaty cases, please.
I will come from both sides, actually. Both sides. We deal with treaty cases, and we have we have quite uncertainty, because litigation funding is a bit fashionable because we want to get as much as we can. When we were looking into investor-state arbitration cases, you look at them, you say, damages are great. Of course, a state will pay the money straight away when there is a decision from World Bank. Then what we came to realization is they are quite expensive as well. Then you come to a state and state says, I don't care about your piece of paper, I am not going to pay for you. Then you start wandering around the world with instructing different types of lawyers and getting asset tracers, taking the award from one jurisdiction to another jurisdiction. Then you end up pulling your hair out saying why these states are not paying, and the states basically become quite a challenging defendant. But when you look at through the CAT, we have to think about CAT. It's quite a new regime, to be honest. Judges are learning with us. It is, of course, on our expense as litigation funders. And so when we think about CAT regime, we are talking about 10 years, but the cases has been coming to CAT on just last 5 years. There are not proper decisions have been given. As far as I know, there are only 4, there are 3 settlements and 1 win in a case. And in each stage, we are learning something else. For instance, the main case that we dealt, and it was really good lesson for all litigation funders, was RIFA case. So we learned that we need to actually train the class rep properly, so they will go there, understand litigation funding agreement inside out. I wouldn't think that any lawyers who were representing that class rep would have known litigation funding agreement that well. Then we came to, now it's kind of good actually coming to the final stage of distribution, but it just seems to be that distribution issue has been left it on litigation funders again. Litigation funders, it's incredibly important to have certainty. I totally agree with Nick. But litigation funders should have certainty, especially contractual certainty, if this jurisdiction wants us to invest in money. I am not going to invest in a, like Christiane said, in a very complex matter, put 20, 30 million. It comes to the end, and I say, okay, non-stakeholder judge sits there, and he says, you know what, I'm going to give another 10 million to Access to Justice Foundation, and they will have another 10 million in their bank account. We have to understand how this distribution will work, and that's why we instruct some firms to do this distribution for us, and what kind of tools can be reaching out to clients more. I think my main kind of lesson from that is how distribution can be effective, what were the issues, and how we can work with these companies to kind of get the word out there. It can be AI, it can be in the news, you can put it on advertisement, put it around tubes, but I think that was the main issue.
No, one point I'd add, I mean, I think, obviously, I want contractual certainty, and as you say, we've told our LPs this is what we expect. Ultimately, I don't know that the issue is contractual certainty or the discretion of the tribunal on distribution. It's more about, as Ayse was saying, there just haven't been enough cases to give us a sort of reasonable range of outcomes. And I'm thinking, again, I'm a US litigator, and I'm thinking in the class action context in the US, every settlement in a class action in the US, a federal class action, gets approved by the judge, and you have no guarantee as the law firm who's bringing the case that you're going to get your 33% contingency or 20%, and it really depends on how complex the case was, how long it went, how much risk the judge thinks you put into it. Different jurisdictions have different, sort of different approaches, whether it's a multiplier of your lodestar, your whip on the case. So the point I'm making here is that in the U.S. There's a lot of uncertainty on class actions, and yet lawyers and funders are regularly involved in there, and it's because we know that, okay, when I'm valuing this case, I might not get 33%, but I'm not going to get 10%, or I'm only going to get 10% if it's a very large settlement, and it'll still work for me. So I think it's really about getting a sort of a band of reasonableness that you can work within. But unfortunately, it's hard to get to that point right now because there are so few cases, and we can't get decisions on cases without funding it. So it is a sort of a difficult situation.
Great. Do you think, controversial question here, do you think the judiciary understand the role of the litigation funder? Obviously, I am totally biased, but I was speaking to part of the judiciary the other day, and they sort of believe that all funders are making fortunes. They just think they get one case, they win, and then they get their 10 times multiple, and it's wonderful. They don't quite realize that you've got to have a team. You've got to look at 100 cases to invest in one case. And then if you're lucky, you can put it to work in it. You wait 5, 6, 7, 8 years. And then you get to the cat, and then they will rip it down to money back plus 1.5 times or whatever it is. So that's an issue. And from our point of view, look, we're a funder. We get our money from other funders. They will look at us and they say, well, look, you can go and do it in the States or go to Holland or somewhere else. So it's a competitive market. And you would have thought, we're all patriotic here, I think. And when you spend £25 million on a case on funding, you've got about £25 million on the other side. That's a lot of VAT and a lot of revenue coming into the government. So maybe one day they should sort of understand. We've got arguably the best judiciary in the world. We've got some great courts, and we should try and maximize that to the full.
I think Europe is, previous panel was also quite informative, has seen how valuable that is it has been for UK, because lawyers now can charge quite substantial amount of money. We created CAT. We have The first case, as far as I remember, was funded in around 2016 in CAT. And those were the first cases, and all the money started to come here. For instance, we are working with some lawyers. They are bringing European actions into UK court. And we are working on MasterCard and Visa case. So there are global clients all around the world bringing their cases to the UK. But we start to see a big competition from Holland because Dutch courts started to see what's happening here and all the wave. We are seeing quite a good movement in Portugal and Spain. And judges, of course, basically we made CAT and we are paying their salaries as well. But if there will be more restrictions, there are other jurisdictions for us to invest, like what happened in Australia when they put all these rigorous rules against litigation funders. We pulled out from the market, they brought a law, and then they changed everything. So that will be the same.
I think the judiciary here, I think you understate the state of knowledge of the important members of the judiciary who, I'm talking about the senior judiciary. The senior judiciary, in my experience, are more than aware and fully supportive of the third-party funding market. I say that without a shadow of a doubt. They are absolutely aware of the importance that funders play in litigation, and that without funders, there'd be, huge disadvantages in all sorts of different areas. Not least, the view that this country takes of its own legal system, and I think they found. I think the PACAR thing has been an embarrassment. That's how I think it's been perceived, and certainly at the senior level where the senior judges are going to be the ones who are making the senior important decisions. They fully appreciate the importance of litigation funding. They may not know how it all necessarily works behind the scenes and all the detail, but they are fully behind litigation funding. I have no doubt about that at all. You only have to read some of the recent judgments in the Court of Appeal to say that. And when I've stood up on my feet saying this case has the potential to, mean that funding isn't available, they are fully onto that, and their decisions are clearly being made with the funding market very much in mind. So,
good.
I think some years ago I would have given possibly a different answer, but there's definitely been a change in approach.
I think they understand it as a concept, but what they don't understand is the actual intricacies and how it really.
They don't understand the intricacies, on that I agree, and I think one of the recommendations of the Civil Justice Council report was that there should be greater sort of exposure to knowledge about how the system works. In fact, they're talking about appointing, judges that will sort of be able to look at agreements in the early days and approve them, and then you'll build up a body of expertise.
And I think one of the points, again, on CJC, which I find very helpful, is judges getting training from maybe litigation funders. We go and explain all the details, how it works.
You actually talk to the judge.
I've given talks to the senior judiciary at the commercial court, and they've asked for it, and we've gone a lot. They're keen to understand how it works. So, but you're right. It's just a slow burn. It's just.
Nick, and sorry, judges looking at the LFAs, but isn't it what KC do? Like, to a certain extent, this task is delegated to obviously another very experienced person, and shouldn't judges have to be like?
Judges, well, the point I was making was that I think the Civil Justice Council was recommending, certainly in the CAT and wider cases, that if there's a funded case, right at the beginning, there should be a judge who can look at the agreement and just resolve any issues about enforceability and so on before it even starts, so you don't deal with it all at the end, and tries to resolve some uncertainty about what might be the outcome at the end. And I think that's a good idea. So you get more. At least the funding market will be more comfortable, and investors will be more comfortable with the case. That judge will obviously have to be educated, but it's not difficult. It's just, it goes on to the part of the course that they have to serve as judges. Litigation funders, and somebody goes along and tells them how it all works.
So it's basically down to you, Nick. It's your job. Nick, it's your job to go and educate the judges then. As I said, I've already done some talks to some of the judges, but I think they can work all this stuff out. Even when they're in the cases themselves,
I mean, people like Hodge-Malik, they're no fools. They're reading these agreements. They understand how these things work. It just takes time for...
It's quite interesting as well. When we talk about CAT, and you probably have seen in investor state cases as well, all the states used to say, because of you guys, there are lots of cases coming against us. And I used to say when I was in UN, say to states, no guys, because of me, they are not coming to you, because I ask lawyers to review the cases from outset, look at damages, potential issues, then it becomes a case. Otherwise, we are the gatekeeper rather than gate opener.
Yeah, we make sure that the good cases come against states. We're not here to fund bad cases because we want to make money.
Exactly.
We're being flashed at. I don't know quite what that means. We may have room for 1-2 questions, if anyone has it. I had loads more. We were going to talk about how costs only go up. I don't quite know why that is, and if that's just a pure coincidence, and is that trend going to change, but we don't have time to do it. So can I just thank the panel for their contributions today? I thought it was very interesting. Thank you very much. And being the last panel, can I just say a very, very big thank you to Eleanor, who has once again, she's done an amazing job with all the Brown Rudnick team, which is fantastic. How you get everyone in the industry to come in from all over the world to come here, it's amazing. So thank you so much.
Just to echo on this, I really wanted to say a big thank you to our moderators, to our panelists, but also to everyone who came here today and for really interesting discussions both on the panels but also outside in the rooms. Someone mentioned that today was a really quiet day on emails because everyone was in this building, in this room. And I think that's true, so thanks very much. I think it's great that this conference has become not only a great deal origination platform, but also a great forum for discussion of those interesting issues. Thank you to Brown Rudnick, to my litigation partners who've flown from the US to talk about those issues, to our events team led by Camilla, to Desiree at Questa Consulting for helping me to do this conference. I hope to see you next year. It'd be very interesting how all of those issues would pan out in a year's time. And please join us for drinks.